The Supreme Court just signaled a shift that could change everything about your right to carry a firearm in public. While most people were looking at the headlines, a critical emergency order slipped through the cracks, and it's already creating a massive legal trap for law-abiding citizens. If you think your state-issued permit covers you everywhere, you are likely mistaken, and this new development makes that danger even worse. We are talking about the High Court refusing to step in on key permit restrictions, effectively leaving lower courts to rewrite the rules of the Second Amendment on the fly. I'm going to break down exactly why this matters, what the court is actually signaling, and how this quiet legal battle is going to impact your daily life as a carrier. This isn't a game of theory anymore. This is about your freedom and your safety, and you need to understand this right now. If you are the type of person who stays ahead of these legal shifts so you can protect your family, join this community by subscribing right now. We track the court orders and the legislative updates so you don't have to get caught off guard when the rules change in your backyard. To understand why this emergency order matters, we first need to look at what the Supreme Court is actually doing behind the scenes. They aren't issuing big, booming declarations that fix the law for everyone overnight, at least not right now. Instead, they are using what legal experts call the shadow docket, which is just a fancy way of saying they are making decisions on emergency requests without a full public trial. By refusing to step into these lower court fights over carry permits, the justices are essentially letting the clock run out while state governments continue to enforce restrictive rules. This is not the same as saying those state laws are constitutional, but it creates a confusing mess where your rights seem to vanish the moment you cross a town line. Think of it like a referee at a high-stakes football game who keeps his whistle in his pocket while one team starts bending the rules to see what they can get away with. Because the Supreme Court hasn't stepped in to stop the clock or blow the whistle on these specific permit restrictions, lower judges feel empowered to keep testing the boundaries of the Second Amendment. This means that in some states you might have the right to carry, but in the next county over, a local ordinance could turn that same act into a serious legal issue. It is a game of legal chicken, and it is regular people like you who are being forced to play the part of the test dummy, risking your own freedom while waiting for the courts to decide what the rulebook actually says. This is where you need to start paying attention, because the confusion on the ground is getting dangerous. We are seeing a flood of new laws that claim to be about public safety, but are really designed to make the act of carrying a firearm so difficult that you might just give up on it altogether. These rules often focus on what are called sensitive places, which are locations where the state claims you cannot carry your firearm under any circumstances. The problem is that these lists of sensitive places are growing longer every single day, turning common areas like public parks, transit hubs, and even sidewalks into potential legal traps for people who are just trying to go about their business. You might think that because the Supreme Court previously said the Second Amendment protects your right to carry outside the home, these local restrictions would be tossed out immediately. That was the assumption for a lot of people. But the reality is much slower and much more painful. The lower courts are using a tactic where they keep these laws alive by saying they need more evidence or more time to study the history and tradition of gun laws. This is a delaying tactic that keeps the laws on the books while you are left wondering if you are about to break the law just by walking down the street with your concealed carry pistol. This is the part where most people get it wrong, and it is a mistake that could cost you your future. People often assume that if a law is unconstitutional, it just stops being a law, but that is not how the system works in the real world. A law stays on the books and can be enforced against you until a judge explicitly tells the police that they cannot enforce it anymore. Just because a law seems to violate the High Court's earlier rulings doesn't mean the local officer at a traffic stop knows that, or even cares. They have a job to do, and that job involves enforcing the rules as they are written right now, not as they might be interpreted in a legal brief 3 years from now. If you have been following these stories, drop a comment below and let me know if you feel like your state is getting more restrictive or more permissive. Your experiences are the best way to see the real-world impact of these court orders, and hearing from you helps everyone in this community stay alert to the patterns we are seeing across the country. Now let's look at why this really hits home for you and your family. If you carry a firearm for self-defense, you are likely already aware of the risks involved in doing so, but the legal risks are often much harder to track than the physical ones. When you leave your home, you have to account for where you are going, what laws apply in that specific jurisdiction, and what happens if you have to use your firearm. But what happens when the legal map keeps shifting beneath your feet because the Supreme Court refuses to issue a clear nationwide order? You end up in a situation where you are forced to navigate a maze of conflicting regulations, and one wrong turn can lead to a misunderstanding that turns your life upside down. Consider a simple scenario that happens every day, like a person driving home from work who needs to stop at the grocery store. In many states, you might have a concealed carry permit that is valid in your home county, but that doesn't necessarily mean you are authorized to carry in a grocery store if that store is located in a different city with different rules. If that city has passed a local ordinance that declares all grocery stores to be sensitive places, you could technically be committing a crime the moment you walk through the automatic doors. Even if you aren't doing anything wrong, and even if you are the most law-abiding person on the planet, the law doesn't always care about your intent. It cares about whether you followed the letter of the law. And here is the kicker that people often miss. The police may not even know about these tiny local ordinances, or they might interpret them differently than the city council intended. You could get stopped for a minor traffic violation, and during the conversation, the officer discovers you are carrying a firearm. Because the laws are so complex and so localized, the officer might have to make a split-second decision about whether to cite you, arrest you, or just warn you. Do you really want to put your freedom and your clean record in the hands of an officer who is just as confused by these changing laws as you are? This is the danger of a system where the Supreme Court refuses to issue a firm, national rule. This chaos is exactly what the anti-carry groups want to see, and it is a brilliant, if frustrating, strategy. By keeping the legal system in a state of constant confusion, they create a chilling effect that discourages people from carrying in the first place. If you are constantly worried about being arrested, fined, or having your permit revoked because you stepped into a prohibited zone that you didn't even know existed, you are less likely to carry. And if you are less likely to carry, then their goal of reducing the number of armed citizens in public is being achieved without them ever having to pass a single, sweeping federal ban. It is death by 1,000 cuts, and it is happening right in front of us. The bigger issue is this. This is a trap for the law-abiding, not for criminals. The people who are planning to do harm do not care about carry laws, city ordinances, or sensitive place restrictions. They aren't looking up the local laws on their phones before they act. The only people who are being hindered by these complex and ever-changing rules are the people who are trying their best to follow the law and protect themselves. This is the central injustice of the entire situation, and it is why the Supreme Court's silence on these emergency orders is so incredibly frustrating for people who believe in the right to keep and bear arms. If you want to know why this matters so much, think about what happens when you have to defend yourself. You are already in the most stressful, life-altering moment of your entire existence. You are dealing with adrenaline, fear, and the absolute necessity of making the right decision in a fraction of a second. The last thing you need to be worrying about in that moment is whether you are standing on the wrong side of an invisible, local, or state-level legal boundary. You should be focused on your survival, not on whether you are going to be charged with a felony because you stepped into a place that the city council decided was off-limits just last month. There is a lot of noise out there about what these court orders actually mean, and it is easy to get lost in the weeds. A lot of people on social media are claiming that because the Supreme Court didn't intervene, it means they are giving the green light to these restrictions. But that is a massive oversimplification. The reality is that the court is often just waiting for the right case or the right combination of cases to come before them so they can issue a ruling that actually sticks. They don't want to make a ruling that is so narrow it doesn't solve the problem, and they don't want to make a ruling that is so broad it ignores the specific legal challenges of the states involved. But that patience comes at a cost to people like you. While the justices wait for the perfect case, you are out there in the real world, navigating a minefield of regulations. This is why I keep telling people that you cannot rely on the Supreme Court to save you from these legal traps. You have to take responsibility for your own understanding of the law in your area. You need to be aware of the laws in your state, your county, and even your city. You need to know where you can carry, where you cannot, and what the specific risks are in the places you visit most often. This isn't about living in fear, it's about being smart and being prepared. Make sure you hit that subscribe button if you want to stay ahead of these legal developments. Knowing the truth about what is happening in the courts is the only way to ensure you aren't the one who gets caught up in a legal nightmare because you assumed the laws were simpler than they actually are. Let's talk about some of the myths that are flying around the internet right now, because there is so much bad information that it's actually dangerous. Myth number one is that your state-issued permit is a golden ticket that lets you carry anywhere in the United States. That has never been true, but people seem to think it is, especially after the Supreme Court made some strong statements about the Second Amendment a few years ago. The reality is that we do not have national concealed carry reciprocity. Even if your home state has very friendly carry laws, that doesn't mean you can just walk into a state with strict laws and expect them to honor your permit. The second myth that I see all the time is that if a law is unconstitutional, you can simply ignore it. Please, never do this. I cannot stress this enough. You are not a judge, and you are not a jury. If you are caught carrying in a place where the law says you cannot, you are going to be arrested, and you will have to deal with the consequences, even if you are eventually proven right in court. A lawsuit to challenge a law can take years and cost a fortune. You do not want to be the person who has to fund that lawsuit from behind bars or while facing the loss of your rights. Follow the law as it is written today, even if you think it is wrong, and fight the legal battle through the proper non-violent channels. The third myth is that the police don't enforce these laws against regular, responsible gun owners. This is wishful thinking. Police officers have a lot of discretion, it is true, but they are also under a lot of pressure to enforce the laws that are on the books. If a department is told to crack down on unauthorized carry, they are going to do it. And if you are the one they happen to stop, you are going to be the one who has to explain yourself. Never assume that your good intentions or your clean record will be enough to get you out of a situation where you are clearly in violation of a local statute. This brings us to the future and what we might expect to see in the coming months and years. The battle over carry permits is not going to end anytime soon. We are going to see more states try to push the envelope with creative, restrictive laws, and we are going to see more lawsuits filed to challenge them. The Supreme Court will eventually have to step in because the confusion in the lower courts is going to become impossible to ignore. But until that happens, we are in for a long and bumpy ride. You need to prepare yourself for a period of uncertainty where the rules are going to be constantly shifting. This is where the next fight starts, and it's going to be fought in the state legislatures and in the local courts. You are going to see more debate over things like mandatory training, background check requirements for permits, and the definition of sensitive places. The goal for those who want to restrict your rights is to make the process of getting and keeping a permit so burdensome that people will eventually stop trying. They are looking for ways to regulate the Second Amendment into oblivion, one small administrative hurdle at a time. And if we aren't paying attention, they might just succeed. What most people still don't see is that this isn't just about the right to carry a firearm. It is about the fundamental principle of whether a government can place an arbitrary burden on a constitutional right. If they can make you jump through hoops to carry a gun for self-defense, what is to stop them from doing the same thing for other rights? What if they decide that you need a special permit to speak in public, or that you have to register your computer before you can express your opinions online? The precedent being set here is dangerous for everyone, not just for gun owners. That is why this fight matters so much, and that is why you cannot afford to be disengaged. Think about the long-term impact on your children and your grandchildren. Do you want them to grow up in a world where their fundamental rights are treated as privileges that the government can grant or take away at will? Or do you want them to inherit a society where the Constitution is respected and where the government is limited in its power to interfere with your personal safety and your liberty? This isn't just about whether you can carry a pistol in your holster today. It is about the kind of country we are leaving for the next generation. That is a heavy thought, but it is one that we all need to take seriously. Let's go back to the idea of the traffic stop. Imagine you are driving through a state that has confusing reciprocity laws. You are carrying your firearm and you have your permit. You get pulled over for a broken taillight. The officer approaches your car and you know you have to disclose that you are carrying. You tell the officer and suddenly the situation changes. The officer is not sure if your permit is valid in this specific jurisdiction or if there are any new, obscure local rules you might have violated. You can see the tension in their body language. They are nervous and you are nervous. This is the reality of the legal confusion we are living in. Now imagine a different scenario. You are in a state that has clear, simple laws where you know exactly what is expected of you and the officer knows exactly what the law is. You disclose that you are carrying, the officer acknowledges it, asks you to keep your hands on the steering wheel, finishes the traffic stop, and you go on your way. That is how it should be. That is how the system is supposed to work. The fact that we have moved so far away from that is a direct result of the legal mess that the courts have allowed to fester. And the only way we get back to that simplicity is through persistent, informed, and peaceful advocacy. Some people might ask, well, why don't I just stop carrying until this all gets sorted out? And that is a perfectly valid personal choice. If you feel that the risks of being caught up in a legal misunderstanding are too high, then you should absolutely prioritize your safety and your peace of mind. But you should do so with your eyes open, knowing that you are making that choice because the system is designed to pressure you into it. You are being forced to choose between your right to defend yourself and your desire to avoid a legal nightmare, and that is not a choice that any free citizen should ever have to make. As we look ahead, here is what you need to keep in mind. The legal landscape is going to remain chaotic for the foreseeable future. You are going to hear conflicting reports on what is and isn't allowed. You are going to see headlines that make it seem like the sky is falling one day and everything is perfect the next. Do not get caught up in the emotional roller coaster. Stay focused on the facts, stay focused on on your local laws and stay focused on being a responsible, law-abiding citizen. That is your best defense against the uncertainty that we are all facing right now. There is a real power in community. When we share what we are seeing in our own backyards, we create a network of knowledge that helps everyone stay safer and more informed. If you notice a new ordinance in your town, or if you hear about a court ruling in your state that is changing the way permits are issued, share that information. Help your neighbors understand what is going on. We are all in this together, and the more we communicate, the harder it will be for the system to keep us in the dark. I want to leave you with a final thought on what it means to be a responsible gun owner in these times. It means that you have to be more than just a person who knows how to shoot. You have to be a person who knows the law, who respects the process, and who is willing to advocate for your rights in a way that is smart, calm, and effective. You are an ambassador for the Second Amendment every time you step out the door. How you act, how you handle yourself, and how you follow the rules matters more than ever. The headlines will scream about the latest court order or the newest political scandal, and they will try to make you feel like you are alone in this fight. But you are not. There are millions of people across this country who care just as much as you do about their freedom, their safety, and their families. We are all working to make sure that the principles of liberty are preserved, even when the system seems designed to push us back. And as long as we keep learning, keep talking, and keep standing up for our rights, we are going to be just fine. So, here is your recap of the 3 most important takeaways from everything we have discussed. First, the Supreme Court's silence is not a victory, nor is it a defeat. It is a period of dangerous uncertainty that you must navigate with caution. Second, the local laws and sensitive place restrictions are the real battlefield, and you need to be an expert on the rules in your own specific area because the law can change from one town to the next. Third, your permit is not a blanket pass to ignore the complexities of the law, and you must prioritize staying informed over assuming you are protected by general principles. This matters in the long term because the legal battle for your rights is a marathon, not a sprint. We are building a foundation for the future, and every step we take to understand the law, follow the rules, and advocate for our freedom helps to secure that foundation for those who come after us. This isn't just about today, it is about tomorrow and the day after that. It is about making sure that the freedom we enjoy today is still there for our children to enjoy in the decades to come. Your freedom and your safety are worth fighting for, but they are also worth being smart about. Do not let the frustration of the current situation cause you to make a mistake that could cost you your future. Stay calm, stay informed, and stay committed to the principles of the Second Amendment. You have the power to protect yourself, and you have the power to be a voice for others who might not understand what is happening. Use that power wisely and always keep your head on a swivel, both in the physical sense and the legal sense. If you are ready to be part of a community that refuses to stay uninformed and insists on taking our rights seriously, subscribe to this channel and join us. We aren't going anywhere, and we are going to keep tracking these legal developments so that you never have to face these challenges alone. Drop a comment below if you found this breakdown helpful, and let me know what you want to hear more about in our next deep dive. Stay alert, stay safe, and I will see you in the next one.